care and the activity is not common. Some jurisdictions prefer to use the phrase abnormally dangerous activity, and they add the requirement that the activity is not appropriate for the location. If that activity is a proximate cause of harm, the person who engaged in the activity is strictly liable for the harm without regard to fault. But remember that proximate cause stuff, because proximate cause is a very important element of strict liability, just as it is an important element of negligence liability. Suppose I'm operating a dynamite factory, and most jurisdictions agree that manufacturing explosives is an ultra-hazardous activity. Suppose I'm operating a dynamite factory, and one night some terrorists break into the factory and deliberately blow it up, and that causes harm to the plaintiff. It's possible for me to argue that the conduct of the terrorists was a superseding, intervening cause, and therefore I'm not strictly liable or liable in any way for the plaintiff's harm. What would make the conduct of the terrorists a superseding cause? If their conduct was unforeseeable, was improbable, was extraordinary in retrospect. Then we would say the intervention of the terrorists was a superseding cause of harm, and the activity in which I was engaging, even though it was an ultra-hazardous activity, was not a legal cause of the harm the plaintiff sustained, and I don't have to pay for it. Those are 4 areas in which the law has traditionally imposed liability without fault, or strict liability. Lately, the law has come up with other areas in which strict liability should be imposed, the most important one being products liability. Most jurisdictions impose strict liability upon a manufacturer or seller of defective products. But we're going to defer that discussion. We'll talk about that when we get to products liability a little bit later on. All right, we have talked about all the bases of liability. Remember I said there are 3 factors to consider in a tort case, and the first is basis of liability. We've talked about all 3 bases of liability. The second factor is proximate cause and damage, and we talked about proximate cause and damage in connection with a negligence case. We've talked about proximate cause and damage in connection with a strict liability case, and I want to remind you